sir.
Good evening.
So first and foremost, can you please briefly introduce yourself?
Okay, my name is Lee Ka Fu, and I'm originally from Selangor, and I'm currently serving as a deputy public prosecutor in prosecution unit, the state of Terengganu.
So, sir, may I know that how long have you been practicing administration of estate law in Malaysia?
Okay, before joining service, actually I was a solicitor and practiced in a civil litigation, and which involve a contentious and non-contentious method, which also include distribution and also probate method. And before joining service, I practiced for almost 2 years, and I have handled few cases which regarding to distribution and also probate method.
Okay, so based on your own experience, could you please explain more regarding the legal principles pertaining to the intestate estate?
All right. First and foremost, we must understand one things that is clear. In our country, the distribution of property is governed by two set of law. Firstly, if there's any will, then it will govern by the law of probate. Secondly, if there's no will from the deceased, and all the property that belong to the deceased will be governed by Distribution Act. Okay. So meaning that for the distribution of intestate estate for non-Muslim is actually governed by Distribution Act, which how the property should be distributed, and also how the property goes to the beneficiary. It will all be governed by this act only. And I would say this Distribution Act actually is quite competent for the intestate method for non-Muslim.
Okay, I see. So for the next question, I would like to ask Tuan Lee. So is regulatory framework of the distribution of interstate estate for non-Muslim competent in Malaysia?
As I said just now, because the non-Muslim method in terms of bequest and also property distribution, it is governed by the law of probate or the law of distribution.
Yes.
And which I would say it is definitely competent, and there are few procedure which the parties need to adhere before they can obtain the property after the death of the deceased.
Okay, sir. So for the next question, I would like to ask that what are the procedures pertaining to the distribution of the intestate legal portions for non-Muslim under the Distribution Act 1958?
Okay, so first and foremost, I would like to explain that in our Malaysia legal position for civil litigation, we have two originating process which we can start any civil suit in court. As far as you are concerned, the distribution of property that belongs to the deceased, it is the jurisdiction of the High Court. So meaning that all the legal proceeding will start at High Court. And for distribution method, usually, because it is mostly it will be a non-disputed method. Therefore, the originating process that govern this application would be by way of originating summons, which is known as Saman Permula in BM. This Saman Permula will actually act as one application in papers and supported by affidavit in support. And this affidavit will be affirmed by the administrator that he or she has the legal duty and responsibility to make sure that everything happen in this application must goes well and goes according to the law. So he or she must make sure that all the property must be distributed as prescribed in the Distribution Act 1958.
So, like for the next question, like if a legal head, like he or she dissatisfied with his or her portion, could he or she bring his or her case to the court?
Alright, for this method, before I go to the core of this issue, I just would like to let you all understand that everyone have their own right to actually initiate any legal action for their interest if he or she is dissatisfied with any decision or any distribution that goes to him or her. Okay. However, as I mentioned earlier, distribution is by way of application of an originating summons, which usually a non-dispute method. In terms of a non-dispute method, meaning that before you actually start filing this application in court, you must have a discussion among the family and come to compromise and come to the consent on who should be appointed as administrator. Apart than that, the issue that is going to discuss in this in the distribution of the property, the family actually or the beneficiary itself actually aware how much or what portion that he or she will get. Usually, there will be no dispute after filing the application because all the dispute will be cleared or will be settled before the whole proceeding starts. However, if after the distributing proceeding has started, even he or she is not satisfied with the portion or any dispute arise among this proceeding, of course, he or she can anytime initiate any legal action to overrule or to against this legal proceeding. But the problem was whether he or she has any evidence to support further to he or she dissatisfaction. This will be the main and also the crux of the dissatisfaction come from, because you cannot just disagree with the portion that you will get because it is prescribed in the Distribution Act. If you are not satisfied, then you cannot file this application. Once you file this application, means that you personally agree to whatever goes to you. So means that I believe if the legal head is dissatisfied with his portion or her portion, it will be very difficult for her to prove a case.
I see. So, sir, when we talk about the law of administration of estate, is there any qualification to be an administrator for the deceased property?
Okay, for this issue, first and foremost, as I said, before you initiate a distribution proceeding by way of originating summon in court, there will be a informal meeting in between the beneficiary, and in the meeting they will actually come into a compromise on who should be appointed as administrator. So the first condition must be complied was the administrator must get the approval from all the beneficiary. Means that everyone must agree that he or she to be the sole administrator for the property. Secondly, this person, he must be a person of sound mind. Means he must be physically and mentally fit to show to the court that he is able to do any distributing works equally, and to make sure that he also can attend to court, because after this legal proceeding has started in court, there will be one hearing date that is fixed by the court, and the counsel that represent the administrator and the administrator himself need to attend the court, and it will be examined by the court officer, and to make sure that he is actually mentally and physically fit. And thirdly, this person, he must not be a bankrupt. Meaning that at the moment that he is appointed as an administrator, he or she must free from any liability, and he must not be a bankrupt, to make sure that his credit will not be challenged by any other party.
Oh, right. So for the next question, I would like to ask: if the administrator had been acted mala fide or failed to execute his duty in a proper manner, could the beneficiaries apply court to disqualify the position of the current administrator in order to regain the deceased property?
Okay, any administrator must be agreed among the beneficiaries, and of course, as I said earlier, this administrator must exercise his power with due care, and he must also act according to the law and according to the advice of his legal counsel. His duty must make sure that the property distributed according to the prescription under Distribution Act. So meaning that he cannot actually acted beyond his capability and acted in a mala fide way, because if he or she committed an offense or being unfaithful or being misappropriated in executing his duty, the beneficiary can actually initiate a legal proceeding or any legal action to challenge his appointment as an administrator, and at the same time to overrule or to challenge any decision that made by this administrator. So meaning that this administrator is actually bearing some legal liability that he or she cannot be exempted from the liability itself. And some more, before this administrator can be appointed, he must sign one course paper that we call as Sumpah Pentadbiran in PM. In this document, actually, he agreed that he will carry out his duty with due care and also acted justly and according to the law. So if he did not comply all this, definitely any legal action can be initiated against him.
So, sir, in a situation where the deceased had a mistress and had already agreed to distribute some of the property to her upon his death, however, this has not been written, recorded, or witnessed by any of the third party. So, when in this situation, does the said oral agreement between them valid, and how would the mistress prove her case?
Okay, for this issue, you all must understand one thing. If a deceased, he had one mistress, so meaning that this mistress did not have any legal relationship with this deceased, right?
True.
Our Distribution Act state clearly the property will only goes to the family or his spouse or his children. So meaning that at this situation, the mistress did not have any legal relationship under the law. Definitely, she cannot entitled to any property unless there is any written will that clearly stated that this deceased has agreed to give certain portion or to give any property to this mistress, and by this way only she can challenge the distribution. But just like what you have mentioned to me just now, if the agreement was not recorded, was not written, and even was not witnessed by any third party, and I would say this agreement is actually very vague in terms of law. And I believe she also did not have any strong evidence to support this, or to support the said oral agreement. And in my opinion, I would say that even she initiate any legal action in court, and her application will fail.
Alright. Interesting. So for the last question, I would like to ask, what is the most memorable or the biggest challenges that you have faced when handling this kind of cases?
Well, being a solicitor, we have to do a lot of things, not just in terms of law. Accept a legal opinion that we give to our client. We must also do a lot of things to make sure that they understand well the proposition of the law, and we must also make sure that after they understand the proposition of law, we as a solicitor, we must also make sure that our client readily to accept whatever position or whatever situation that might be happen in certain cases. And I would say the bigger challenge was always difficult to deal with the client, where the client is I would say stubborn,
Oh, stubborn.
and I believe client will always be the biggest enemy for any legal practitioner. So we must make sure that they understand well and they accept whatever prescribed in the law, and at the same time we must make sure that they are not being emotional.
Yeah.
And most of the time, if they are being emotional, sometimes they will not follow what has been prescribed in the law, and they might be acted impulsive if their portion was not satisfied them.
Yeah.
So I would say the bigger challenge was always dealing with the client.
So yeah, so this marks the end of our interview. On behalf of our team, we would like to express our gratitude towards Tuan Lee
No
for
problem.
spending your time and having this interview with us. So yeah, thank you very much.